Good day everyone, and welcome to another discussion in our What If series, where we bring you insights in the format of a what if question on the ever-evolving landscape of employment law. I'm Ross Simon from Moolman Corporate Employment Law, and in today's discussion we will be unpacking what if an employer dismisses an employee for provocative WhatsApp status. When is dismissal fair? In the modern workplace, social media misconduct, especially on platforms like WhatsApp and Facebook, has become a frequent trigger for disciplinary action. But the law is clear. Not every inappropriate, offensive, or provocative post will justify dismissal. The core inquiry is one of substantive fairness, whether dismissal is an appropriate and proportionate sanction in all the circumstances. To illustrate how our courts approach this, we look at a recent Labour Court decision in the matter of Errorite Proprietary Limited, trading as Kailicha Superspa, versus CCMA and others. The employee, Mr. Gogo, a Zimbabwean national, was employed as a bakery manager at Kailicha Superspa. At the time, the workplace was already under strain because a local Facebook group was accusing the store of hiring foreign nationals and calling for protest action. Some employees involved in that Facebook activity were disciplined, and management had instructed staff to keep a low profile during this volatile period. Against that backdrop, Mr. Gogo posted a verse from Deuteronomy as his WhatsApp status. He shared it in the WhatsApp management group and on his personal WhatsApp status. The verse effectively stated that foreigners would gain power over locals and become their rulers, a plainly provocative message in a climate of heightened xenophobic tension. He later apologized for the post in the management group, saying it had appeared there by mistake due to a problem with his cell phone, but he maintained his right to keep it on his personal status. The employer viewed this as very serious misconduct that risked fueling division in an already inflamed environment and dismissed him after a disciplinary inquiry. Mr. Gogo then referred an unfair dismissal dispute to the CCMA, seeking compensation rather than reinstatement. The CCMA found that the dismissal was substantively unfair and awarded him 3 months compensation. Importantly, the Commissioner rejected his accidentally posted explanation and accepted that he intentionally posted the verse. The Commissioner accepted that the message was provocative, that he disobeyed an instruction to keep a low profile, and that it was a serious error of judgment. However, the Commissioner drew a clear line between this conduct and the more dangerous Facebook posts which openly incited protest action and had a stronger link to potential violence. In the Commissioner's view, Mr. Gogo's conduct did not amount to hate speech or incitement to violence. Taking into account the apology, the removal of the post from the management group, and the context, the Commissioner concluded that a final written warning, not dismissal, would have been appropriate. The employer took this award on review to the Labour Court, and it argued that the Commissioner had underestimated the seriousness of the post, especially given the xenophobic tensions, and that dual publication to management and to the public via status justified dismissal. The Labour Court dismissed the review and upheld the CCMA's award. The Labour Court emphasized that the question is not whether the court itself would have dismissed, but whether the Commissioner's decision falls within a range of reasonable outcomes. Here, the Commissioner understood the context, accepted that the post was deliberate, and still concluded a final written warning was appropriate. That was the value judgment he was entitled to make. The court accepted that the message was provocative and posted at a highly sensitive moment, but it agreed that it did not cross the line into hate speech or incitement. It also stressed the distinction between Mr. Gogo's conduct and the Facebook group's more direct role in fueling xenophobic mobilization. The apology, the removal of the post in the management forum, and the absence of clear malicious intent all counted against dismissal as a proportionate response. So, what does this mean for our what if question? When is dismissal for a provocative WhatsApp status fair? This case does not give employees a free pass on social media, but it does underline that dismissal is a last resort. Some key lessons emerge. A bad WhatsApp post, even in a management group, does not automatically justify dismissal. Employers must show real or reasonably foreseeable harm, not just offense or embarrassment. There must be a clear link between the content and its impact on the business or the workplace. Context matters. Existing tensions, prior instructions, and the sensitivity of the environment all affect the seriousness of the misconduct. Publication on a group and a personal status can aggravate matters, but it is not decisive on its own. The employee's response afterwards, removing the post, apologizing, and whether there was malicious intent will be central to the appropriate sanction. Ultimately, proportionality is key. Even where the conduct is deliberate and provocative, a severe warning may still be a fair outcome rather than dismissal. That brings us to the end of this week's discussion. We hope you have found it informative. Thank you for joining us. If you have any questions or comments, we'd love to hear from you. You can find us on social media, or you can email me on ross@massconsulting.co.za. Until next time, goodbye.